I told Gigi, who is honestly my favorite member of the public interest community, that we have a big intellectual tent here at the Federalist Society. So I think she has proven herself to be a bona fide member of the Intellectual Diversity Club. We, of course, are litigating the case for Comcast that precipitated the agency's NPRM. I'll get to that story later. In Washington, there's always a story and a backstory. The litigation is the backstory to the proceeding that we're discussing here today. But first, I'd like to touch briefly on the options for the FCC's next step that Greg and Gigi touched on. Greg mentioned seeking legislation. They both mentioned Title II reclassification. Greg didn't mention, and Gigi touched on, and I'd like to suggest a third way. How about the proper lawful use of ancillary authority? Even if the D.C. Circuit reaches the statutory authority in the Comcast appeal, which they may not, because Comcast actually urged decision of the case on a much narrower procedural ground, the most the D.C. Circuit could hold is that the agency erred in adopting the Comcast order. So you might imagine an opinion that said that Section 230 and 706, as Greg noted, are not appropriate bases for the exercise of ancillary authority because they're just policy statements. So the agency, even in that world, would still be free to do the hard work that is required to lawfully exercise ancillary authority. Nothing in the Comcast appeal or in any appeal of this NPRM would result in a judicial ruling that there is no FCC authority over the internet or even internet access. We all know what the Article III case and controversy limitations mean, and that means that any decision by a court is limited to that which is before it, that dispute. So again, there's a lot of panic in the streets over the need to go to Title II reclassification. But why couldn't the agency find the substantial evidence that was necessary to show that the exercise of ancillary authority was necessary to the execution of an actual statutory function? That will still be, I would imagine, permissible under the law. So you don't need to throw the baby out with the bathwater and run to Title II. Again, novel concept in Washington for administrative agencies, but how about the lawful exercise of ancillary authority? That's a third way that's getting absolutely no attention in this debate. Ancillary authority, of course, the judicial test for the lawful execution of that power is necessarily a fact-specific analysis, that second prong that Greg noted that really contains all the action here, looks at the particular rule that was adopted and the agency's explanation for the need to adopt that rule in order to execute some other function. So I would submit respectfully to Gigi that it's not clear that USF rules or data roaming rules or consumer protection rules would be off the table. If the agency can tie rules like that to a specific statutory mandate, some substantive part of the act, not a hortatory policy statement, make the record to show that it can't do its job under those provisions unless it regulates under its ancillary authority in this related area, that could well stand. So I think we ought not exaggerate kind of the debate. I know it's fun and it makes it sexier to talk about, but there are fact-specific analyses that would be undergone, and that's still a path for the agency to pursue. Brand X, of course, upheld the initial classification of internet services as information services. And of course, I love all Justice Thomas opinions. And because I love them so much, I read them very carefully. So while the quote that Gigi drew our attention to is in the opinion, the end of the opinion also says, we express no opinion on the exercise of ancillary authority that was teed up in the rulemaking there. And there was, of course, no ancillary authority question presented to the court in that case. It was only the reclassification question. So it's important to notice, to I think what Justice Thomas meant was agencies are free to try to exercise Title I ancillary authority, and we'll have to wait and see whether any future exercises of that authority would be upheld under the test in a particular case or controversy. So now to the backstory. We all in this panel know this, but not everybody in the room. The NPRM was precipitated by our litigation. In August of 2008, the FCC sanctioned Comcast for violating its internet policy statement. At the time, I felt like Alice going down the rabbit hole because everybody around me was talking about the enforcement of a policy statement. And the last time I had checked, a policy statement had the legal force and effect of law, the same legal force and effect as this sheet of paper that I just wrote my notes on. It's not law. It's not promulgated pursuant to the APA. It's nonsense to talk about violating a policy statement. That, in fact, is what we told the D.C. Circuit. And we urged the narrow resolution of the case on that ground, which would actually have no effect whatsoever on the NPRM. Not Gigi's group, Public Knowledge, but Free Press, the public interest group that brought the original complaint against Comcast, was the only party in the litigation that stood up in the Court of Appeals and urged the court to reach the statutory authority question. Both Comcast and the FCC asked for a narrower resolution. So if the court gets to that question, it will have been really at the urging of Free Press and certainly not of Comcast. On the same day that the FCC filed its brief in our case, it issued its NPRM. I don't think that was a coincidence. One of the things we had argued in our case was that the agency had acted improperly because, as I mentioned, they enforced a policy statement against us. No rule, no regulation, no agency precedent, no law, no nothing, except for a policy statement. We think it was an inherent concession of that legal error that the agency, at the same time it was defending its position in our case, rushed a notice of proposed rulemaking out the door to turn the policy statement into law and therefore to apply it to internet access providers on at least a prospective basis. It, of course, would not cure any problems as to Comcast because this is past conduct that occurred well before even the issuance of the NPRM. So it's often interesting to see what the competing motivations were. And while the NPRM looks kind of like an interesting, attempt to tackle this subject, I thought the group might be interested to know that it, in our humble opinion, was an attempt to cure, at least going forward, the really fundamental legal problems in the Comcast order and the sanctions that our client, at least, was subject to. So those are my parting thoughts here, adding to the wonderful comments of my colleagues. There is a third way here, the lawful exercise of ancillary authority. Yes, it requires hard work. Yes, it requires the building of a record, but that's what agencies, in my humble opinion, are supposed to do. And secondly, the backstory here is the Comcast litigation that really precipitated the NPRM. And my final point is that regardless of what happens in any of the proceedings, it is, I humbly submit, not accurate to say that all FCC authority over the internet will be gone. It will mean that particular rules failed to withstand judicial review under the fact-specific ancillary authority test, and other rules, like USF rules, if they could be properly tied to the right provision in the Communications Act, could well withstand judicial review. Thank you.
Thank you, Helga.